He was born the same year Mao Zedong declared the founding of the People's Republic of China. He wanted the law to say he was born the year astronauts first walked on the moon. In November 2018, a 69-year-old Dutch motivational speaker walked into a district court in the city of Arnhem and asked a judge to do something no Dutch court had ever been asked to do before. Legally erase 20 years from his life, not through surgery, not through a new identity, through the law itself. His name was Emile Ratelband. By the time his case reached a verdict, it had made headlines from London to Los Angeles, not because he won, but because of exactly how and why he lost. Ratelband was no stranger to reinvention or to the spotlight. For decades, he had built a career as a motivational speaker and a trainer in neuro-linguistic programming, the world of self-help, positive thinking, and personal transformation. Dutch media called him a showman. International outlets called him a positivity guru. His media career even stretched to voicing a character in the Dutch language dub of Pixar's Cars 2. He had spent a lifetime telling other people they could change who they were simply by deciding to. In 2018, he decided to test that philosophy on the one thing modern law insists no one can change: the date they were born. By his own account, the idea had been building for a while. He said a doctor had examined him and estimated his biological age at somewhere between 40 and 45, decades younger than the 69 years printed on his passport. He seized on the gap. If his body didn't match his birth certificate, he reasoned, why should the birth certificate win? He told reporters the number 69 left him limited in business, in opportunity, and he was very open about this, in dating. He said that when his real age showed up on Tinder, women simply stopped responding. It wasn't just romance either. He said a younger official age would let him, in his own words, buy a new house, drive a different car, and take on work he felt had quietly closed off to him. He had a phrase for how he saw himself. He called himself a young god. This wasn't a spur-of-the-moment stunt either. Court reporting later revealed he had retained a lawyer for the case roughly a year and a half before it ever reached a judge. So, in November 2018, Ratelband filed a formal request with the district court in Arnhem, change his official date of birth from March 11, 1949 to March 11, 1969. 69, on paper, would become 49. His central argument was the one that made the case a global talking point. The Netherlands, like a growing number of countries, allows citizens to legally change their registered name. It also allows people to legally change their registered gender. Ratelband's question to the court was blunt. If identity could override the paperwork in those cases, why not here? You can change your name. You can change your gender, he said. Why can't I decide my own age? His lawyer made the same case publicly, telling reporters it was time for the courts to allow this kind of reversal, much as they had already allowed others. He wasn't asking for a symbolic ruling either. He told the court he was willing to give up the years of state pension tied to his real age, real money, forfeited voluntarily, in exchange for the change. At one point, the court raised a practical objection. What about the records of his own parents? Ratelband had an answer ready. Both of his parents were already dead, he told the judge, so there was no one left to object. Even before a formal ruling came down, the signs weren't encouraging. Dutch press reported that the court had already indicated, during the proceedings themselves, that no existing legal mechanism allowed a person's date of birth to be changed at all. The court said it would need up to 4 weeks to reach a final decision. It took almost exactly that long. On December 3, 2018, the Arnhem court delivered its answer, and it was no. The judges didn't dismiss how Ratelband felt. Their written ruling explicitly stated that he was free to feel 20 years younger than his real age and to act accordingly. Feeling younger, the court made clear, was never on trial. What was on trial was whether that feeling could legally rewrite an official record. And there, the answer was firm. The reasoning went deeper than a simple technicality. A name can be changed on a document without disturbing anything else about a person's legal history. A gender marker can be updated the same way. Age, the court explained, is different. It's woven into a dense web of rights and obligations. The age at which someone can vote, the age they're required to attend school, the age they can legally drink, drive, or marry. Rewrite the birth date, and every one of those thresholds loses its meaning, not just for Ratelband, but as a precedent for anyone. The judges even turned his own logic back on him. If age could be adjusted downward simply because someone felt younger, they reasoned, nothing would stop a person from petitioning to be declared older instead, old enough on paper to drink, drive, or marry before they actually qualified by any measure. The very protections those age minimums exist to provide would collapse. There was a deeper cost, too. Changing his date of birth wouldn't simply add a number. It would erase 20 years of entries from the Dutch Registry of Births, Deaths, Marriages, and Partnerships, the very records the state relies on for an accurate account of who a person is. 2 decades of his real, documented life would effectively vanish from the books. The court also rejected the idea that personal free will alone could override legal reality. It even acknowledged something sympathetic to Ratelband's broader point, that people today are living healthier and feeling younger for longer than previous generations did. But it ruled that a social trend, however real, wasn't grounds to rewrite one man's birth certificate. On the discrimination claim at the heart of his case, the judges found Ratelband hadn't actually shown evidence he'd been discriminated against, and pointed out he was already protected under existing Dutch law without needing to change a single digit on his birth certificate. The ruling closed on a single guiding idea. The state's records are meant to reflect the truth as it happened, not the truth as someone would prefer it. Most people, told by a court that their entire legal argument had failed, might feel defeated. Ratelband did not. Facing reporters after the ruling, he called the decision fantastic. Not because he'd won, he clearly hadn't, but because, in his view, the written ruling had handed him a roadmap for what to argue next. He told CNN he planned to appeal right away, treating the judge's own reasoning as ammunition for a future case. The story didn't stay confined to the Netherlands. Within days, it had been picked up by broadcasters and newspapers across North America, Europe, the Middle East, Africa, and Asia, landing somewhere between a legal curiosity and a genuine cultural flashpoint. His comparison to transgender rights drew particular criticism from commentators who argued that equating a chosen number with a person's lived gender identity trivialized the latter. Organizations that track age discrimination took notice too, not because they endorsed his methods, but because the case put an unusual spotlight on how differently the law treats age compared with other parts of a person's identity. What happened to the appeal itself is harder to pin down. Ratelband was vocal about his intent to pursue one in the days after the ruling, but no further court decision on the matter appears in the public record. Whether a formal appeal was ever filed, withdrawn, or quietly dropped remains, based on available reporting, unresolved. Strip away the punchlines, and there were plenty in newsrooms that couldn't resist them. And the Ratelband case asked a real question. Not whether one man could legally become 49, but what a birth certificate is actually for. Is it a record of biological fact? A tool the state uses to organize rights and duties? Or, as identity becomes more fluid in other areas of the law, something that should bend to how a person sees themselves? The Arnhem Court gave its answer in December 2018. A birth date is not an opinion. It's a fact the state is built to protect whether or not the person who owns it agrees. Emile Ratelband walked out of that courtroom exactly as old on paper as he'd walked in. But the case he left behind is still cited whenever the conversation turns to identity, bureaucracy, and the very human refusal to accept the number printed on the page. 20 years, it turns out, are not so easy to sue away.